11 minutes gone past the hour of 5. You're listening to 92.3 Nigeria Info. Remember, you can watch us live on Facebook, Nigeria Info PH, live on YouTube, Nigeria Info PH. And we are active on X, Nigeria Info PH. You could also follow me on social media, Dkalada, THEKALADA. All right, that being said, welcome to another segment on Hard Facts, today's edition. And this time, I want us to talk about the conflicting court orders that has now put Rivers' 2024 budget at risk of not being implemented, so to say. Now, yesterday, for those of you who do not know, I am Kalada Korubatibo, and I will introduce my guest shortly. He is a lawyer, a good one at that, and I'll be getting his thoughts on the issue on ground. Now, was it yesterday? Was it the day before? We saw the report. We even talked about it as part of our big stories yesterday, where a federal high court in Abuja, where Justice James Nwokocha was in charge, gave a judgment saying that the governor of Rivers State, Siminalayi Fubara, His Excellency, should resubmit, or in this case, should submit the budget before the Martin Ameule-led assembly, saying the submission done before the Edison Eye-led assembly was null and void. He said the governor should not overreach his powers as enshrined in the Constitution. That, he said so many other things. But the one that really caught my attention, and I think I mentioned it yesterday, was the part where he said and acknowledged that the Rivers State governor and the people on his side had withdrawn their lawyers. But he also did say that the withdrawal of the lawyers was acceptance of the facts before the court, and that was that Martin Ameule is the true speaker, and he is leading the assembly, and as such, of course, the budget should be passed to that assembly, which is the authentic one. There were so many other things that were mentioned in that judgment. We'll look at it as the conversation continues, or as we go on the conversation. However, just yesterday, there was another court judgment from another high court. I stand to be corrected. I think it's an high court. And the report did say that everybody maintained status quo. Now, I've seen Justice Abdul Malik of the Federal High Court, Abuja, directed all parties not to take further steps pending the determination of an application that seeks to stop Governor Siminalayi Fubara from resubmitting the already passed 2024 budget of the state before the Legislative House. Now, Justice Abdul Malik fixed February 28 to hear the application, which was brought before the court by 6 elders of the state. Now, the lawmaker representing Bonny State constituency, Victor Okojumbo, I beg your pardon, led the elders, including Bennett Birabi, Andrew Uchindu, O.P. Fingesi, Ann Q. Briggs, and Emmanuel Deima. Justice Abdul Malik ordered that the court papers be served on those sued through other means. Justice Abdul Malik's directive comes shortly after Justice James Nwokocha of the Federal High Court in Abuja ordered Governor Fubara to resubmit the 2024 budget to the Martin Ameule-led Rivers State Assembly. Now, while we are still looking at court cases, there was another court case today, this time at the Rivers State High Court. However, the case was struck out. The suit was struck out. The suit was seeking to restrain Governor Fubara, just like, Justice Abdul Malik's case, or the case before Justice Abdul Malik. This time, the court struck it out, saying it lacks the jurisdiction to hear such a matter. Now, the person presiding over this court, Justice Chinwendu Nwogu, in his ruling, struck out the suit for lack of jurisdiction. The suit brought before it by the representative of Bonny State's constituency, Victor Okojumbo, and others seek to declare the peace agreement brokered by President Tinubu as unconstitutional. All right, I've got Professor Ritchard Nwokocha. He's a professor of law lecturing at the Rivers State University, and is on the phone, and we will talk together. Welcome, Prof. It's good to have you after a long time.
Thank you, Father Kuru, and good evening, Nigerians.
All right, so you've seen and heard the various court cases, the various court reports, all pertaining to the Rivers case, or the Rivers political case, or should I say the legislative case in Rivers State. However, there was an interview done with the Commissioner for Information, and this is what he had to say. Let's take a listen.
That's the situation. The president directed that the governor and his team should withdraw all court cases, and we did in obedience to that directive. So the judge that went ahead to give judgment didn't give us fair hearing and relied on whatever the plaintiff filed. It's quite sad that it happened. Governor did it to fulfill all righteousness and to de-escalate the unnecessary tension, and in total submission to the directive of Mr. President. So it tells you that whereas we are on our own path trying to keep to the proclamation, them on the other part are still pushing ahead. This is a sad development.
All right, Prof, first question to you is, can Justice Abdulmalik's court still give judgment on a matter that is similar to what Justice Nwokocha has dealt with?
My answer would be yes.
Okay.
First, if it is brought to his attention that a matter has been fully contested and decided by a court of equal jurisdiction or coordinate jurisdiction, as we call it, he ought to be wary of giving judgment. But as we reported, the matter was not contested. I had this feeling, generally, since we are speaking without having seen the certified full copy of the judgment. I had this feeling that that suit was not contested, because if it was, that court could not have arrived at the decisions it arrived at. And that has been made clear now by your reportage that the governor, probably in keeping with the understanding he had with some parties in Abuja, withdrew his lawyers. That means that there was no defense to the suit, and the court went ahead and granted what was raised, uncontested. However, since the issue is also before another court, and for the court to reach a position yesterday, the possibility is that the matter has already been filed. So if an order has been made, it is now the responsibility of the other parties to try to convince the court as to why it should not continue, and to convince it that the judgment given by the other courts should stop him from continuing. But remember, again, it's not the same subject matter.
Is it not? Is it not?
It's not quite the same subject matter. One of them is talking of a number of things: stoppage of salary of assembly members, interference with sitting and venue of sitting, preventing from National Assembly from taking over legislation for Rivers State, preventing the governor from requesting the National Assembly to intervene, ordering the Inspector General to provide security for them, and all that. That's a completely different suit from this one, in which what is before the court is, look, the governor has presented budget before what we consider an appropriate assembly. The reasons for considering it an appropriate assembly will be contained in your argument. And the reasons for saying that the others are not competent persons will be in your argument. So broadly, what will be before Justice Abdulmalik would be the issue that these men have resigned by having defected, they have vacated their seats, and so they were no longer assembly members before whom budget could be presented. That would be the argument in this case before Justice Abdulmalik. So they are not quite the same case, and they are not the same parties.
So I get you now. Sorry, Prof. So you're saying that even though the resultant effect would be on the budget or about the budget,
yes,
it's not the same case.
No, the first suit is not about the budget.
Okay. But the budget was
It's
also
not
mentioned.
about
The budget was asked to
the
be
budget. The budget was mentioned, but it's not a suit entirely about the budget.
Okay.
And the grounds on which the second suit is based will bring out issues that were not before the court in the first suit. Because naturally, to be the right thing to do and the natural thing that court should order that governor should do his work. If you haven't presented budget, present it, etc., etc. But if a court is faced with the question whether the people who are raising these issues have competence, which is what should have come from the governor's reply, the reply of the governor's team to that suit. But the governor withdrew his team, meaning that there was no response from his side. So the court went ahead. So there are different suits. They are dealing with different issues. The issue before Justice Abdul Malik will be raising the issue of whether the 7 persons are assembly members and therefore whether they have competence to receive the budget.
All right.
And that would be their justification for asking the court to uphold what was done with the people who were valid members of the assembly. So it's not the same suit, it's not the same members. And secondly, the issue was not contested at the other side, so it wasn't fully hard on the merits, so to speak.
All right.
On this other side, the parties who are different are raising a different issue that will raise the question of validity and competence of the 27 members of the assembly.
Now
so,
let's go back.
Can go ahead.
Let's go back to Justice Omotosha's court for a bit now and the judgment he gave.
Yes.
He also acknowledged the fact that the governor's part of the divide withdrew their lawyers, and you had the commissioner for information in that audio clip saying that they did withdraw indeed in obedience to the peace accord that we talked about a lot once upon a time. What is the standard operation in a court proceeding? Let's say I'm a party to a suit and I withdraw my lawyers and I say I don't want to continue with the case, even though I am the defendant, can the judge give judgment without me being properly represented?
A case is usually brought before the court by a claimant. Asking the court to do what he has prayed the court to do. If the defendant files a defense, the court is expected that the court will hear the defense and reason the validity of the defense vis-a-vis the claim of the claimant before he reaches a judgment. Now, if the claimant withdraws his suit, the case ends. But if the defendant withdraws his defense, the case continues, because even in the writ that is served on you, it is stated there that if you do not enter a defense, the court will proceed and judgment will be entered in favor of the plaintiff or the claimant. So if the defendant withdraws his participation, the court will go ahead and give judgment because the case is still before him. So it will be uncontested and he will have to grant what has been prayed if the other party establishes them. He will have to grant them.
So in the so when we'll come back,
that's what he said.
When we'll come back, we'll continue. We have a commercial break. Right. Do hold on, please. We'll be right back.
All right.
Listening to 92.3 Nigerian Info. This is Hard Facts, and I am Khaled Akurubatibo, and I've got via the phone Professor Ritchard Nwokocha. Is a professor of law and a lecturer at the Rivers State University. Welcome back on the show, Prof.
Thank you, Khaled.
All right, now before we went for the commercial, we were talking, and you were trying to explain to me withdrawal of case and no withdrawal of case, how it happens. If the petitioner withdraws the case, you said it is done with, the case is done with. But if the defendant withdraws his lawyers or his defense, it is not a withdrawal of case. So in this case now, before Justice James Nwokocha, was it not the defense that withdrew, or was it the petitioner that withdrew?
It was the defendant. It was the defendant that withdrew his counsel. That's the River State government.
Okay.
So it's not the petitioner. That's why I said the court will go ahead to make the others praise. As the court explained in the judgment, it took in that the withdrawal of the defense team was an admission of the case of the claimant. So they went ahead and made these others win. So if the defendant withdraws, the case will go on. The writ itself, writ of summons or intimating summons, usually contains that information that if you do not enter appearance and defend the suit, that the court will go ahead and hear the matter and give judgment in favor of the plaintiff or against you.
Okay.
So if the defendant withdraws, the case goes on because it's not his case. He didn't bring the case. The man who approached the court for relief will go on with his matter, and the court will give. If he proves his relief, the court will grant the prayers.
Now, Prof, you said the cases, the one with judgment already from case? I'm going the one with judgment already from James Nwokocha, Justice James Nwokocha, yes. And the one now before Justice Abdul Malik. You said they are two different cases. However, they have been able to Justice Nwokocha has been able to pronounce that the budget be resubmitted. Now that Justice Abdul Malik has said, hey, do not implement resubmission of budget, everybody maintain status quo. The question I have is, which of the judgments should the River State government obey? Because one is a judgment of courts. Remember, they are both of coordinate jurisdiction, right? One is a judgment of court. Another is an order, not necessarily a judgment. Say, hey, maintain status quo. Do not do anything pending the determination of, this case. So which is the River State, in your legal opinion, supposed to obey? Because it has to be obedient to the laws of the land.
Let me make this clarification that the disobedience of a court judgment and disobedience of a court order carry the same effects.
Okay.
They are both acts in contempt of the judgment or order of the courts.
Okay.
So it carries the same effects. Incidentally, these are courts of coordinate jurisdiction. So the danger that comes with courts of coordinate jurisdiction giving conflicting judgments is that everybody is in disobedience and everybody is in obedience. If a party chooses to adhere to one of the judgments or orders, he is protected by the fact that he is obeying the order or judgment of a court. The other party's protest would be, you're disobeying the judgment or order of another court, but they are courts of equal jurisdiction. So it really it makes nonsense of the whole thing and leaves every party with the choice to choose which one to obey, because they are both orders of the same high court. Different different judges, but the same court's level of thought, the same courts of coordinate or equal jurisdiction. So the River State government will be at liberty to choose what it wants to do, because either way it goes, it is obeying the judgment or the judgment order of a court.
Okay. Do you think the NJC should step in? Do you think they would have to step in? Because, like you said, the the confusing part of having both judgments, or one judgment, one order, is that you don't know which one to obey. If you obey this one, it means you're disobeying the other one, and you're still found culpable. And if you're obeying the other one, it means you're disobeying this one. So do you think the NJC should jump in, or do you think it should be escalated to the Court of Appeal already?
Well, when you have this situation, the next step is for a party to go to the Court of Appeal, for a higher court to make an order which will be binding and which will supersede that made by the courts of equal jurisdictions. Remember that this drama did not begin with the judgment and orders of yesterday. Prior to this time, a court of coordinate jurisdiction, a court of equal jurisdiction, as these two federal high courts in Abuja, had made an order here, empowering the remaining members of the House to take the step required by the Constitution, and declaring that those who left their positions or who vacated their seats were no longer members of the Assembly, and that this one should go ahead and do what the Constitution requires. And they did what they did based on
what the court said. Yeah.
And the order of the court. They didn't even need the order of the court. But in this case, they went to court and the court gave an order. So they acted in obedience of the Constitution and in obedience of the child of the Constitution, which is the court established by the Constitution. So even by the time courts were sitting yesterday, if it was brought to the attention of those courts that, look, this has already happened, which the defense would have done if it did not withdraw its defense, it will mean that the courts acting yesterday had a responsibility to take cognizance of the fact that such orders had been made and that they were not supposed to go on with what was brought before them.
All right.
So the fact that what happened yesterday happened is only an addition to existing orders already made by courts of equal jurisdiction, the same high court system, this time state high court. They are all high courts. Federal high court, state high court, national industrial court, they are all courts of equal or coordinate jurisdiction. So the drama is just going on. What happened yesterday is in addition to what had already happened prior to this time.
Okay. Let's open the phone lines now. I know you're listening. Let's get your thoughts on the issue. Right now in Rivers State, the political drama is still ongoing. It's still lingering. And, if not for the explanation of the Prof, I actually did think that there were conflicting judgments, so to say. However, I have been tutored and I've been taught on the show that they are not necessarily conflicting. They may, meet at some point, which is, of course, the budget, the Rivers State budget 2024. However, one has to do with the happenings and the running of the House of Assembly, while the other has to do with the validity of the members of the Assembly. Have they vacated their seats or not? That's the argument of the other court. So, we can argue that they're different things. But he has also said the appeal court should be brought into the mix, given the fact that there are two courts of coordinate jurisdiction on similar matters. Just for clarity's sake, because I would have preferred if the NJC stepped in, but I'm being told the Court of Appeal would have to do the stepping in. I've got Mufasa from NTA Road, but I've not reeled out the numbers. For those of you who are first-time listeners, these are the numbers: 0817 923 0002 and 0817 923 0003. WhatsApp number 0809-030-6416. WhatsApp number is for WhatsApp messages, not for calls. Please do not call. I've got Mufasa from NTA Road. Mufasa, welcome on the show. What is on your mind? I'd like to hear.
Hello.
I can hear you. Go ahead.
Yeah, thanks for the opportunity. I want to say a very resounding good afternoon to your guest. I think he has done justice to the matter. For me, even as at yesterday, when that judgment came, I wasn't excited because, as far as I'm concerned, I'm not a lawyer, but my pedestrian knowledge of the law, I know that what was just exhibited yesterday was, for me, an academic exercise. If you don't know that High Court in Abuja and High Court in Port Harcourt they are all courts of equal and what they call
coordinate jurisdiction.
Coordinate jurisdiction. But I just want to ask the Prof for clarity's sake. Now, does the judgment of Nwokocha, yes, the judgment of Nwokocha, does it invalidate the actions taken by Right Honorable Edison Iye as at the time he was Speaker of the House? When I mean the actions taken, I'm talking both the acceptance of the budget and the processes that led to the signing of the budget by the Governor of Rivers State. Does that Nwokocha, does it invalidate that action? Because I'm aware, and I've watched and equally said that Justice Danagogo gave them such power. So for me, I do not think they faulted the law, but does that judgment does it invalidate those actions taken by Right Honorable Edison at the time he took those actions?
All right, Mufasa, we'll get back to your question. Let's listen to Chinoye. Chinoye is calling from Elele. Chinoye, welcome. What is on your mind? Please tell me.
Okay. Kalada, good evening.
Yeah, greetings to you.
I regard to the learned gentleman, learned professor in the studio.
Okay.
Hello?
I can hear you. I said okay. Go ahead.
It's a hopper. Look.
I can hear you clearly. I can hear you. Just go ahead. I'm listening to you. All right. Prof, let's come to you now. Mufasa is asking, you made reference to it not so long ago, talking about another high court giving legality to Edison Iye's time as speaker and the activities undertaken during the time, because you mentioned it, talking about budget resubmission and all. And he's asking, does this Justice Nwokocha's judgment invalidate that judgment, given that they are of the same jurisdiction, equal jurisdiction?
No, it does not at all. It does not at all invalidate the judgment of the High Court, State High Court, that gave those orders. Because they are courts of equal jurisdiction. If anybody wants it invalidated, he is to go to the Court of Appeal to get a judgment to that effect that will consider that judgment and make pronouncement to the effect that that judgment was not right. And this is what the position should be. So several courts of equal jurisdiction making pronouncements on the same thing do not counter each other.
So what does this then mean? Because I think I asked this question earlier, but I'm going to ask it again. What does this then mean of that? What does it mean, the judgment of Justice Nwokocha? What does it mean, given that it gave validity to Martin Amaewule's led assembly?
What it means is that they can claim to be going on. But a very important thing to be had in mind is the fact that that court did not deliberate on the issue of the fact that those men had
defected to another party.
Defected to another party, and whether they remain valid members or not.
Okay.
They brought the action claiming to be members. The action was not defended. Counsel that appeared for governor was withdrawn in compliance with a one-sided agreement that he should withdraw his cases while the other ones are not to withdraw. And he withdrew his counsel or his defense team. And the court went ahead and granted the prayers of people who came before the court. So their position was not an issue. Whether they were valid persons or not to bring the action was not an issue.
Okay.
Now, as things stand, they are to go before Justice Abdul Malik to show why it is proper for the budget to be resubmitted to them. And when they get there, they will meet the objection that they are no longer assemblymen.
Okay.
Because that is the basis of the action that is there. And that court will have to make a pronouncement, make a finding and a pronouncement on whether or not they are competent persons to parade themselves as assistant assemblymen and to demand that budget should be brought before them, whether they are competent persons for the governor to act towards as representatives of the constituencies and as assemblymen.
All right. Let's take a call from Bright, who's calling from Oyibo. Bright, welcome. What is on your mind? I like to hear. Yeah, greetings to you. Bright, I'm struggling to hear you.
Can you hear me now?
Okay, better now. Go ahead.
Yes. You asked the Prof between the order from Justice Malik and the judgment from Justice Nwokocha to experiment. They say the both can be obeyed. I think that is the very big issue. A court judgment takes preeminence over a court order. And that is why if you have looked at what Justice Nwokocha did today, Justice Nwokocha did what during the Appeal Court saga and Supreme Court saga and Presidential Tribunal, what they said is called issue estoppel in law. Once a subject matter has been delivered in judgment by another court, you can't litigate on it either by the same party or another party.
But Bright, can I pause? Bright, can I pause you now? But now, what the Prof is saying is they are not the same issue. Now, on one hand, Martin Amewule is saying, hey, National Assembly should not come to Rivers State. National Assembly should not take over legislative activities in Rivers State. The government should not... Wait, I'm going somewhere.
Issues that were delivered yesterday in before Justice Nwokocha.
That's what I'm listening. I'm listening down for you. I'm listing out the issues for you. Whereas,
okay, I'm listening.
I've just said it had to do with national, House of Assembly issues. Talking about who is supposed to be in charge. Talking about
the representation of budget.
Exactly. Money's supposed.
And even Edison acting as a speaker was also a matter that was delivered. Judgment was given yesterday by Justice Nwokocha.
Okay.
There are a lot of issues.
Okay. Now let's go to Abdul Malik. Abdul Malik is based on the defection of lawmakers. Are we on the same page now?
Saying it's not the only matter before.
But I'm saying the main suit is defection of lawmakers. So are you seeing that it's...
No, it's not.
Okay, so educate me. Educate me. All right, I'm listening.
Let me make my point and go, because what I'm trying to do now is to sound a warning or to bring to our notice, not warning, that we are already misinterpreting what are in the suit.
Okay.
So that when the judgments come, we will not come on air to cry. The issue there is not only about defection. There are some of the issues there before Justice Abdul Malik that had already been decided yesterday.
Give me an example. I'm listening to you.
Example of it is that the governor should not resubmit budget.
Oh, now Bright. That's what I was trying to explain to you, which you would not let me. Now I am trying to explain to you that the resubmission of budget is coming up again based on the primary subject matter, which is that these people have defected to another political party and as such should not receive the submission of budget. I don't know if you get where I'm coming from.
Yes.
So it's a different political matter.
I say political, yeah. Edison yes. It is on the basis of Edison declaring their seat vacant that these persons are instituting the suit for Malik, right?
Yeah.
Now, before Justice Nwokocha, he has notified every action taken by Edison.
But it cannot be.
Their seat vacant. It's null and void. You can't use it.
Right now, I understand you, but you're not understanding me. Now, the Prof said Justice Nwokocha cannot declare all the activities of what's his name, Edison, because one, you've just said. Wait now, I'm going some. Allow you talk and I talk. Now, okay. Justice Nwokocha is also going to be countering a court of coordinate jurisdiction because there was a court order that made Edison Ehieh speaker for a bit. Now, secondly, before the court, they did not mention defection. But go ahead.
No, there were issues that were later filed and consolidated and new parties were joined.
Go ahead, I'm listening to you.
Get the background of what Justice Nwokocha did yesterday.
Okay.
Before Justice Nwokocha, issue before Justice matter before Justice Nwokocha has been existing, and he has made an order. He reiterated it in his judgment yesterday. Before ADC and his group instituted the court issue that gave them the power to act.
Okay.
Already Justice Nwokocha's case, and there were a restraining order against them before the judgment of Justice Nwokocha, which already that matter has been withdrawn, and the only order Justice Nwokocha made is dead.
Okay.
Justice Nwokocha pointed to disobedience of his order.
Okay.
Yesterday in his judgment.
Okay.
I am pointing out because lawyers will come to try and criticize the judiciary when they have not fully brought up try to understand the advance of the matter. A lot of issues were dealt in that judgment. Any other place we are going, we'll come back here and try.
Okay, Thank you. Thank you very much, Bright. Thank you very much. Good to hear from you. Isaiah from Buguma, welcome. What is on your mind? Quickly, please.
Yes, excuse me. Let me greet the learned legal illuminary in the studio.
Quickly, please. There is no time,
Prof,
Isaiah. Okay,
yes,
quickly.
More grace to your elbow. You see, Canada, you see, I want the Prof to throw more light. It should lighten this very aspect of my question, which is, he is saying that the yesterday judgment was a judgment that was handed down, and the one that was later followed by the Rivers elders were also, that was an order. And at the end of the day, I listened to him, and he was saying that at the end of the day, it takes a higher court, which is the Court of Appeal, you understand, to decide. So, don't you think the whole thing is a little bit confusing? One is a judgment, one is an order.
Okay.
And they are all from the same equal court of jurisdiction.
Okay.
You understand? And the one judgment is already adjudicated, and the other is just an order that was pronounced. And at the end of the day, the Prof is saying that it takes an appellate court, which is a higher court, to now say what he understands, to come to a logical conclusion. So I want, it's like, for me, I'm not.
All right. Isaiah, all right. Thank you very much. Keep listening now. Back to you, Prof. We've got a commercial in 60 seconds, but you heard what Bright said. Bright said, like I mentioned earlier, that there are similarities in the court cases. However, he's saying the similarities are too, what's it called now? How do I describe it? The similarities are too close enough, or are very close enough, and so Justice Abdul Malik's court cannot decide on some of those cases. Do you agree with it? We'll go for a quick commercial. When we do come back, I'll get your final thoughts and then we'll wrap things up. But let's say this one. This one says the political gladiators should please allow Rivers people to drink water and drop cup. The drama is becoming shameful. Fidelis Elemoa from Nwokocha Che. Sepri Boy is saying, my question is the state government still appealing the judgment of yesterday? Or should there be room to defend their matter with their evidence? Will it be admissible? All right, when we come back, we'll look at all of that. Just stay tuned.
We'll be right back after this.
When you wake up on the wrong side of your bed, you wake